Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor as we talk about responding to a request for a hardship deduction. A hardship deduction is an exception to the guideline formula, that is the statewide formula that California uses to determine child support. It has to be based on very specific circumstances which are set forth in Family Code 4071. It either needs to stem from a party experiencing extraordinary health expenses for which that parent is financially responsible and or uninsured catastrophic losses, or it has to stem from the party that is requesting the hardship deduction having other children that he or she is financially obligated to provide support for, and their minimum basic living expenses exceeding that parent's ability to provide. When you are faced with a request for a financial hardship, please keep in mind that the request is subject to the court's discretion, and it's really going to depend upon your ability to argue that it is not justified for that party to receive a hardship deduction. The most obvious objection would be if the party is requesting a hardship deduction for something that is not listed as one of the specific circumstances that we have already discussed. For instance, if they are saying that I have a parent to support, I have a stepchild to support, that does not fall under the specific circumstances set forth in Family Code Section 4071. While a parent may be morally responsible to provide for those people in his life, he or she is not legally responsible for that person, and that's an important distinction to make. The court also needs to balance the request for the hardship against the needs of the children that are in question and subject to this court order. It does not make sense for the court to grant a hardship deduction to a parent who's requesting it if it ends up harming or taking away from the children that are subject to this court order. I think a lot of times we have to get a little creative with the arguments we present to the court. And again, it may work for one judge, it may not work for another judge. Some examples of creative advocacy. If a child that the parent is basing the hardship on is older, such as 16 years old, you could argue that their reliance on that parent to financially support them is less than that of a younger child. And that also kind of goes into the balancing of hardships that we previously discussed. Another argument you can make is if you are aware that there is no child support for the parent, for the children that the parent is basing the hardships on, you could argue that that parent also has an obligation to seek out child support from the biological parent of those children and has not made efforts to do so. I have, and this doesn't work with every judge, but I have successfully argued that if the children that the parent is basing the hardship on came after the children that is subject to the court order, that shows a pattern of poor decision making on the obligor's part, that he continues to have children that he cannot financially support. Again, what sways one judge may not sway another judge, but this is an instance where I suggest throwing the spaghetti at the wall and seeing what sticks. I hope you found this helpful. Good luck.